Your Honor, before you this morning is the matter of the State of Ohio versus Santos Tucker. We're before the court for purposes of sentencing the defendant having pleaded guilty and being found guilty of 1 count F4 assault. Parties are ready to go forward, Your Honor.
Ms. Tomaszek.
Yes, thank you, Your Honor. We would like to ask the court today to give Mr. Tucker an opportunity on community control sanctions. Your Honor, in speaking with Mr. Tucker, he has had an opportunity to meet with Larry Heller from NORA. It is something he's very interested in. There is a bed available for him. I do understand that Mr. Tucker also does have a holder out of Cuyahoga County currently for a warrant. Our office has been in contact with his probation officer there, and the intention is to have Mr. Tucker on their mental health docket. From the start of this case, Your Honor, up until now.
What's the warrant for? Anybody know?
I believe it's in the PSR, Your Honor. It was a failure to appear.
Okay.
I believe it was for an F3 tampering and F4 theft.
The warrant's on his failure to appear on his probation. Is that right?
Oh, yeah, sorry. He did the CBC after Cleveland successfully completed that, but did not appear to probation after completing the CBC.
Right.
All right. Yeah, he failed to report to probation since his release from the county jail on February 21st, 2026. And then he was booked into Lake County Jail on this case, and he's been here since. So I know they do have a holder. We've been in contact with probation out there just because Mr. Tucker did successfully complete the CBC app. So they do want to have him on the mental health docket. From the start of this case to now, Mr. Tucker did definitely present some mental health issues. I understand he was on a very high dosage of medication, since been on the correct medication to jail. So he's getting that under control. Mr. Tucker has also been very upfront and honest about his drug use. He knows he has an issue. He knows he needs to get that resolved. So I do believe, and he believes that Nora would be a good fit for him. So we'd just like to ask the court today for an opportunity to place him on community control, allow him to go to Nora, and allow him an opportunity on the mental health docket in Cuyahoga County. Thank you.
Okay, Mr. Tucker, what do you want to tell me?
What I went through was really unjust, and I just wanted help. And this treatment facility is not a high drug traffic area, and I have constant back pain from getting police brutalized. I don't want to say that it's a hate crime.
Back pain from what?
Police brutalized, and even in this county jail, I've been neglected by CEOs. So I really don't wish to speak anymore. I just want rehab, honestly. I suffer from 13 years of crack cocaine addiction and have taxes to pay, family members, gas, utility, and such forth.
So you don't want to, you say you don't want to get into what happened. It was just either this or at the jail. Is that right?
Oh, both parties. That like racial discrepancy, but I just want help. I'm tired of using, and this is a good treatment facility for me.
Well, that's a matter of opinion, quite frankly, but you're very violent.
Can be not.
You are. I mean, your past indicates you're violent.
Correct.
You were violent this night. You've been causing constant problems in the jail. Talking about getting the guards, or I forget the exact words you said, but there's no getting past the fact that you're violent, and it's probably rooted. I think it's probably 3 parts. You're violent, you've got mental illness, and you like drugs, and you put all those things together, and you're fighting with the cops in Painesville for no reason.
He had a gun. I didn't.
What?
They had firearms. I didn't.
Yeah, well, they didn't point a gun at you.
Yes, they did.
One guy had a taser out, and he didn't use the taser. Okay. Now, when I read this report, he should have used the taser. That would have probably alleviated a lot of the problem. But they didn't go to the extent of using the taser.
That's because my friend's mother, whose car I stole, she's 1,000 pounds, and she was yelling. And Mauser, the same size as me, stopped the little cop from shooting me.
Cop wasn't going to shoot you. Didn't have his gun out.
And then it was a dog on the scene. All I remember, honestly, from my standpoint, is a woman of 1,000 pounds yelling, "Stop, get off of him." And I have asthma, and they cracked my head on my skull on the side of the ground and my teeth.
And
I have nothing else to say.
And yet you elbowed him right in the face.
That's self-defense.
Well, maybe we should have a trial. Are you telling me you didn't assault the police officer? Because you pled guilty to assaulting the police officer.
Yeah.
Are you telling me you didn't assault the police officer?
I'm not saying that at all.
Okay. Who's Trina Bentley?
Who is Trina Bentley?
Who's Trina Bentley?
That's my auntie.
Why did you tell her, why did you say to her, I'm about to fuck these guards up again?
Because people in there were fraternizing with me. Like, those messages you're reading wouldn't even make sense to you.
I don't know. You want to help me make it make sense that I'm about to fuck these guards up again?
That's
Yeah.
every time I got neglected and beat up.
Beat up by who?
Certain CEOs that are racist.
Okay. Okay, anything else you want to say?
No.
Mr. DePiro.
Your Honor, the state position is the defendant is not amenable to community control. This is the second time that he's convicted of assault on a police officer while he's on felony probation. The first time was in 2019. Judge Michael Shaughnessy, he was on probation for an F2 robbery back then, got 2 years of probation, and then less than a year into it, he gets convicted of an F4 assault on a police officer. Judge Shaughnessy sent him to prison for 2 years. One of those years was for the assault on a police officer concurrent to the 2 years, but that must not have been enough, because here we are again. So the state recommends prison because you can't hit cops, you can't assault cops, and there's got to be a punishment for that. Thank you.
Thank you. All right, I've reviewed the pre-sentence report, the psych report. Didn't receive any victim impact statement. And I have considered what Mr. Tucker has said, what counsel have both said, considered all the provisions in 2920 and 11, 12, and 13. Your record as an adult starts when you turned 18. Drug abuse, misdemeanor, disorderly conduct, misdemeanor, criminal trespass, misdemeanor, attempted assault, misdemeanor, domestic violence, assault, endangering children, misdemeanors, obstructing official business, misdemeanors. 2018, F2 robbery and F5 drug possession, sent to prison. Got out in October of 23, so spent almost 4 years in prison. That was after violating probation. So while you were on probation, you got an obstructing official business misdemeanor assault with a police officer, felony 4 in 19. That's when you went to prison. October 5th of 23 is when you get out. May of 24, got a felony tampering with evidence, felony 4 aggravated theft. Cuyahoga County, placed on probation, violate probation. And then while you're on probation, you pick up this assault, felony 4. And clearly, the officers dealt with you verbally. One took out his taser, was, as I said, probably should have used it, but didn't. You created the fight. You started the fight. 2 of these guys rolling around with you, trying to get you under control, and you elbow one right in the eye. Over since you've been at the jail, March 13, March 16, March 18, March 31, April 7, April 13th, April 15th, April 17th, April 30th, May 5th. All incidents with you. So, as I said, Mr. Tucker, you're a violent person. You haven't done anything to curtail that violence. You have no intention of curtailing your drug addiction because you like it, apparently. And you got mental health problems. So you are not amenable to community control based on everything I just indicated out of the pre-sentence report, including your previous time in prison. So I'm going to sentence you to 18 months in prison with credit for 95 days, and the costs are assessed. When you get out, you might be on post-release control for up to 2 years under the parole authority with conditions. Anything else? Remaining charges are dismissed. Anything else, Mr. DePiero?
No, Your Honor. Thank you.
Ms. Thomasek?
No, Your Honor, thank you.
All rise.
This courtroom sentencing hearing centered on Santes Tucker, a man who had pleaded guilty to a fourth-degree felony assault charge involving a police officer. The hearing quickly evolved into a discussion about violence, addiction, mental health, accountability, and whether Tucker deserved another opportunity through rehabilitation or whether his history demonstrated that prison was the only realistic option. While Tucker and his attorney argued that treatment and mental health services could help him change his life, the prosecution and the judge focused on his extensive criminal record, repeated violent conduct, and ongoing problems while incarcerated. By the end of the hearing, the judge concluded that Tucker was not a suitable candidate for community control and sentenced him to prison. The hearing began with Tucker's attorney requesting that the court place him on community control rather than impose another prison sentence. The defense explained that Tucker had recently met with representatives from a rehabilitation program called NORA and had expressed a strong desire to participate. According to his attorney, there was already a bed available for him, meaning he could begin treatment immediately if the court approved the placement. The attorney informed the judge that Tucker also had an outstanding probation-related warrant in another county, but probation officials there still hoped to place him on a specialized mental health docket. The defense argued that this showed other professionals still believed Tucker could benefit from treatment and supervision rather than incarceration. The attorney further pointed out that Tucker had previously completed a correctional treatment program successfully and had shown signs of improvement while receiving proper mental health medication in jail. The defense portrayed him as someone struggling with serious personal issues who genuinely wanted help. The defense spent significant time discussing Tucker's mental health and addiction problems. According to his attorney, Tucker had exhibited obvious mental health issues throughout the case. At one point, he had reportedly been prescribed an extremely high dosage of medication, but jail medical staff had adjusted his treatment plan and placed him on medications that were more appropriate. As a result, he appeared more stable and better able to manage his condition. The attorney also emphasized that Tucker had been honest about his long-standing substance abuse problems. Rather than denying his addiction, he openly admitted it and acknowledged that he needed treatment. The attorney argued that rehabilitation would provide a better solution than incarceration because it would address the root causes of Tucker's criminal behavior. In the defense's view, sending him to a structured treatment environment could help break the cycle of addiction and criminal conduct that had defined much of his adult life. When Tucker addressed the court personally, his comments revealed a mixture of frustration, resentment, and desperation. He began by claiming that he had been treated unfairly, and that many of his struggles stemmed from what he described as police brutality and mistreatment while incarcerated. Tucker stated that he suffered from chronic back pain and blamed some of that pain on interactions with law enforcement. He also accused jail staff of neglecting him while he was in custody. However, despite raising these grievances, Tucker repeatedly stated that he did not want to spend much time discussing them. Instead, he insisted that what he truly wanted was rehabilitation. He explained that he had been addicted to crack cocaine for approximately 13 years and was exhausted by the lifestyle associated with addiction. Tucker spoke about wanting to return to a normal life where he could work, pay taxes, support family members, and take care of everyday responsibilities. He told the court that he was tired of using drugs and believed that the treatment program being offered represented a genuine opportunity to change. The judge listened carefully, but immediately challenged Tucker's attempt to frame the case primarily as a treatment issue. According to the judge, Tucker's history showed something much more troubling than simple addiction. The court bluntly told Tucker that he was a violent person. While Tucker attempted to object, the judge pointed to his criminal record and the circumstances of the current offense as evidence. The judge argued that Tucker's problems appeared to stem from a combination of three major factors: violence, mental illness, and drug abuse. In the court's view, those three elements repeatedly combined to create dangerous situations. Rather than seeing someone who simply needed rehabilitation, the judge saw a person who had demonstrated a consistent pattern of aggression toward others, especially law enforcement officers. This became a recurring theme throughout the hearing as the judge repeatedly returned to Tucker's history of violent behavior. The discussion then turned toward the events that led to the assault conviction. Tucker attempted to portray the incident as a chaotic encounter in which he felt threatened and mistreated. He described confusion at the scene, recalled seeing officers, a police dog, and various bystanders, and claimed that he suffered injuries during the confrontation. According to Tucker, he remembered people shouting and attempting to intervene while officers restrained him. However, the judge was not interested in revisiting the facts of the case because Tucker had already pleaded guilty. The court pointed out that Tucker had admitted to assaulting a